Hello everybody, I'm delighted to be with you today to discuss the SFC's latest consultation on the proposed Code of Conduct on book building and placing activities in equity capital market and debt capital market transactions, and the separate proposal on sponsor coupling. We're going to begin today with an overview of Hong Kong's equity and debt capital markets and current market practices, followed by a summary of the SFC's concerns with respect to the book building and allocation process in Hong Kong. We'll then look at the SFC's proposed Code of Conduct provisions, the types of offerings and intermediaries that will apply to, and the standards of conduct that will be required. We will close the webinar with a discussion on the sponsor coupling proposal and the SFC's rationale for proposing it. So on February the 8th, 2021, the SFC published a consultation paper with two main proposals. The first is a new Code of Conduct with requirements for intermediaries conducting book building and placing activities in equity and debt capital markets transactions. The second is the so-called sponsor coupling proposal, which would require at least one head of the underwriting syndicate or a company within the same group to also act as an independent sponsor. The proposals apparently followed a thematic review of selected SFC licensed intermediaries engaged in equity capital market or debt capital market Hong Kong book building and placing activities and discussions with market participants. That review apparently found that in some offerings, the price discovery process had been hampered by various factors, such as inflated or opaque demand. The SFC also identified cases of what it considered to be undesirable intermediary conduct, such as brokers without a mandate swarming order books at the last minute with orders of what it refers to as unknown quality. The SFC's thematic review also identified good practices, which it proposes to codify. Separately, the SFC identified that sponsors' fees and costs and liabilities are often misaligned, particularly in larger IPOs. According to the SFC, this raises concerns that IPO sponsors may compromise their due diligence work to become the head of the underwriting syndicate and earn the much higher fees that come with that to make up for their costs for acting as sponsor and potential liability. The SFC is therefore proposing to impose various obligations on intermediaries involved in Hong Kong book building and placing activities in a new paragraph 21 of the SFC's Code of Conduct for persons licensed by or registered with the SFC. The SFC refers to these intermediaries as capital market intermediaries or CMIs, while the syndicate head is referred to by the SFC as the overall coordinator or the OC. The SFC is also proposing that syndicate membership and fee arrangements should be determined early and that capital market intermediaries and overall coordinators should be appointed under written agreements which set out their roles, responsibilities, and the fee arrangements. On IPOs, the sponsor coupling proposal will require that at least one OC must be appointed as a sponsor, and this sponsor must be independent of the issuer. The SFC's stated objectives in introducing the proposals are to address their concerns regarding intermediaries' conduct, to deal with issues arising from competitive pressures, and to align incentives with the responsibilities of intermediaries. The consultation closes on the 7th of May 2021, and respondents' comments will then be considered and consultation conclusions will be issued, together with a revised Code of Conduct and the gem placing guidelines. As market participants may need to update their internal controls and procedures to implement any new requirements, the SFC is proposing a 6-month transition period for the industry to comply following gazetting. Price discovery in Hong Kong is conducted by way of book building, which, when carried out transparently and fairly, the SFC thinks serves the interests of both issuers and investors. The SFC says in the consultation paper that competitive pressures have led intermediaries to engage in conduct which often tips the scale in favor of issuers. This, it claims, can distort the price discovery process and the allocation of equity and debt offerings. However, there are currently no specific conduct requirements for intermediaries involved in Hong Kong book building and placing activities. Through the thematic review, the SFC has identified a number of concerns with the book building and allocation process. The SFC's first concern relates to the roles and functions of the various intermediaries involved in capital raising activities in Hong Kong, including heads of syndicates, other syndicate members, and brokers. The SFC found that generally, written agreements entered into by intermediaries do not clearly set out their roles and functions, and that intermediaries' titles sometimes have little bearing on their seniority or responsibilities in relation to the transaction. With regard to syndicate membership, the SFC says that some market participants have informed the SFC that what it calls conventional appropriate issuer practices, including appointing the heads of syndicate at the outset of transactions before kickoff, and issuers treating the heads of syndicates as their trusted advisors on marketing strategy and the pricing and allocation. These market participants apparently also describe it as normal market practice for underwriting fees to be agreed at the outset of the transaction, comprising a fixed fee for syndicate members' advice and preparatory work, and the amount of the offering they're expected to sell, and a discretionary fee to incentivize sales performance. The consultation paper notes concerns that some issuers have deviated from these market practices by only determining fee arrangements and syndicate membership shortly before the publication of the IPO prospectus or shortly before book close on debt offerings. The concern is that allowing intermediaries to join the syndicate at the last minute means that they will not be familiar with the issuer and unable to market the offering properly. With regard to incentive structures, the SFC found that while fixed fees have traditionally made up the largest share of underwriting fees, some issuers now allocate significantly more to discretionary fees. It's claimed that some issuers reward syndicate members for their ability to support very aggressive pricing, and that some syndicate members focus more on the quantity of orders than the quality of orders, particularly price-insensitive orders from corporate and individual investors. The SFC's concern is that price-insensitive demand can drive up the share price to a level desired by the issuer, but which cannot be sustained in secondary market trading, resulting in steep declines in post-IPO share prices and thin liquidity. The SFC's thematic review also determined that some intermediaries were knowingly placing inflated orders and overstating demand, which undermines the price discovery process and can mislead investors. Another major concern for the SFC is the apparent lack of transparency of the order book, which it says prevents syndicates' heads from assessing real demand or identifying unusual or irregular orders. It's particularly concerned about the use of X orders in debt capital markets transactions, where investors' identities are concealed and known only to the syndicate members who place the orders and the issuers. The SFC's concerns include that the use of X orders may result in unusual, duplicated, or potentially fictitious orders not being identified. Issuers can request X orders to conceal the identities of prospective investors with whom they're closely associated in order to inflate market-driven demand in the order book. Sell-side market participants sometimes use X orders to prevent other syndicate members from poaching their clients. And some investors, especially sovereign wealth funds, may ask for X orders to conceal their participation in a debt capital markets transaction. Conflicts of interest are another source of concern. The thematic review found that some syndicate members did not give priority to orders placed by their investor clients over their proprietary orders. The SFC is also concerned that syndicate members with access to the order book are privy to non-public information, which they could use to increase their chances of allocation in popular deals, for example, by revising orders to make them more attractive than those of other investors. In debt transactions, the SFC found that while rebates to private banks are not meant to be passed on to private banks' clients, this does occur. The SFC considers that this undermines the fair treatment of investors, as different investors, in effect, pay different prices for the same debt securities. In the equity market, the SFC notes that cases of brokerage fees being rebated to IPO investors take place, effectively reducing the share price paid by these investors. The SFC found that heads of syndicate didn't maintain records or maintained insufficient or inadequate records of incoming client orders, important discussions with the issuer and syndicate members, or the basis for making allocation recommendations. The SFC's thematic review also identified some potential breaches of the Hong Kong Exchange's requirements, including cases where syndicate members had attempted to allocate IPO shares to clients with which they were associated without seeking prior consent from the exchange. Turning now to the SFC's proposed Code of Conduct. The proposed code will regulate intermediaries conducting book building or placing activities in Hong Kong. Book building activities are defined as collating investors' orders, including indications of interest in a share or debt offering, to facilitate price determination and the allocation of shares or debt securities to investors, or the process of assessing demand and making allocations. Placing activities are defined as distributing shares or debt securities to investors pursuant to book building activities. The proposed code will also apply to intermediaries who advise, guide, and assist issuers in Hong Kong book building and placing activities. Intermediaries engaged in these activities are referred to as capital market intermediaries, or CMIs. CMIs don't include financial advisors or other professionals who advise the issuer, but who don't participate in book building or placing activities. In terms of the type of offerings covered, the proposed code will apply to shares to be listed on the Hong Kong Exchange, issued by a listing applicant in an IPO, including a share offering in relation to secondary listings. Offerings of shares of a class new to listing and offerings of new shares of a class already listed under a general or special mandate. The proposed code will also apply to units or interests in SFC authorised real estate investment trusts, REITs, listed or to be listed on the exchange, and shares listed on the exchange when a shareholder places its existing listed shares to third-party investors, followed by a top-up subscription of new shares by the shareholder to the extent that these offerings involve book-building activities. In terms of debt capital market transactions, the proposed code will cover all types of debt offerings involving book-building or placing activities conducted by intermediaries in Hong Kong. These will include listed and unlisted bonds, bonds with complex features, bonds issued by sovereigns or corporates, bonds targeting retail or professional investors, and high-yield issues. The proposed code won't cover offerings which do not involve book-building activities, such as bilateral agreements or arrangements between issuers and investors, such as club deals, transactions involving only one or several investors where the terms of the offering are negotiated and agreed directly between the issuer and the investors, and transactions where shares or debt securities are allocated to investors on a predetermined basis. The proposed code will also not cover a share offering which has been subscribed by an intermediary as principal, deploying its own balance sheet for onward selling to investors or otherwise. The proposed code will define the overall coordinator as the head of syndicate for an offering by reference to the activities it conducts rather than by its title. In a share offering, an overall coordinator is a syndicate capital market intermediary which solely or jointly conducts any of certain specified activities. The first being the overall management of the share offering, coordinating the book building or placing activities conducted by other capital market intermediaries, exercising control over book building activities, and making allocation recommendations to the issuer. The second activity is advising the issuer of the offer price and being a party to the price determination agreement with the issuer. The third is exercising the discretion to reallocate shares between the placing tranche and the public subscription tranche, reducing the number of offer shares, or exercising an upsize option or over-allotment option. And the fourth activity is acting as the stabilization manager. In the case of a debt offering, an overall coordinator is a syndicate capital market intermediary, which solely or jointly conducts the overall management of the debt offering, coordinates the book building or placing activities conducted by other CMIs, exercises control over book building activities, and makes pricing or allocation recommendations to the issuer. All other CMIs fall within the category of syndicate CMIs or non-syndicate CMIs, depending on whether they have a mandate and a direct relationship with the issuer or not. Examples of syndicate CMIs include book runners, lead managers, co-managers, and placing agents, while non-syndicate CMIs include, for example, sub-placing agents or brokers, which only collate orders received from their investor clients. Turning now to the standards of conduct expected of CMIs. These are set out in paragraph 21.3 of the proposed code and are baseline requirements with which all CMIs would have to comply. Paragraph 21.4 sets out additional requirements applicable to overall coordinators only. Let's look firstly at the proposed requirements on conducting an assessment of the issuer and the offering. The SFC found considerable variance in the scope and depth of CMI's assessments of issuers and offerings and noted the need for CMIs to gain a proper understanding of the issuer and the offering to market shares or debt securities to their investor clients. The proposed code will require that before engaging in an offering, a CMI should take reasonable steps to obtain an accurate understanding of the issuer, which may vary depending on the type of offering and the role played by the CMI. This assessment should include obtaining a sufficient understanding of the issuer's history, background, performance and business, financial conditions and prospects, operations and structure. An exception is provided for a capital market intermediary for a debt offering which has been a CMI for a previous debt offering by the same issuer. In that case, the CMI should ascertain whether there have been any material changes in the issuer's circumstances of relevance to its role as a CMI. To help CMIs assess the issuer and the offering, the SFC also proposes that an overall coordinator should share information about the issuer with syndicate CMIs, or take reasonable steps to ensure that the issuer provides this information to them. This information should then be shared with non-syndicate CMIs. The proposed code will also require CMIs to establish a formal governance process to review and assess the offering before entering into an offering. The formal governance process should review the offering and assess any actual or potential conflicts of interest between the capital market intermediary and the issuer and associated risks. This would generally involve designating a member or members of senior management to assess, for example, the structure of the offering, any actual or potential conflicts of interest between the capital market intermediary and the issuer, and associated risks involved in participating in the offering, financial or reputational. CMIs will also be expected to maintain sufficient resources and have effective systems and controls in place to ensure that they can properly discharge these obligations. The proposed code will contain provisions on the timing of appointments of capital market intermediaries and overall coordinators, and the need for appointments to be made under written agreements which set out the fee arrangements. The consultation paper notes that underwriting agreements for share offerings and subscription agreements for debt offerings are typically entered into late in the offering process, usually when the price has been fixed and allocations to investors are finalized. These agreements do not generally define the roles and responsibilities of CMIs, and underwriting agreements for share offerings typically specify intermediaries' underwriting commitment, which does not necessarily correspond to their fee entitlement. In debt offerings, it's also the norm to appoint syndicate heads verbally without written agreements. The SFC is therefore proposing that before a capital market intermediary, other than an overall coordinator, starts any book building or placing activities, it has to have been formally appointed by the issuer or another capital market intermediary in the case of a non-syndicate capital market intermediary to conduct those activities pursuant to a written agreement. The written agreement will be required to clearly set out the roles and responsibilities of the capital market intermediary, the fee arrangements, including the fixed fees as a percentage of the total fees to be paid to all syndicate capital market intermediaries, and the fee schedule. On a share offering, the overall coordinator will have to be appointed before it provides any services as overall coordinator, and in any event no later than 2 weeks after the listing application is submitted to the Hong Kong Stock Exchange. On a debt offering, the overall coordinator must be appointed before it conducts any book building or placing activities. Overall coordinators will need to be appointed under a written agreement which specifies the OC's roles and responsibilities, the fee arrangements, and the fee schedule. The SFC is proposing that the OC of an offering should advise the issuer on syndicate membership, fee arrangements, marketing strategy, and pricing and allocation. An OC will be required to ensure that its advice and recommendations are balanced and take into account the issuer's preferences and objectives with respect to pricing and prevailing market conditions and sentiment. The proposed code will require OCs to ensure their advice is aligned with all legal and regulatory requirements. On a share offering, an OC will need to advise and guide the issuer and its directors on the exchange's requirements for placings under Appendix 6 to the main board listing rules and Chapter 10 of the GEM rules, and take reasonable steps to ensure that they understand and meet those requirements. OCs will also need to ensure compliance with the specific requirements for an offering of debt securities listed on the exchange. Chapter 37 bonds, for example, can only be offered to professional investors. OCs will be required to explain the basis of their advice and recommendations, including any advantages and disadvantages. For example, OCs should communicate their allocation policy to the issuer and explain the factors behind the allocation recommendations. Advice should be provided in a timely manner. Where an issuer decides not to adopt an overall coordinator's advice or recommendations in relation to pricing or allocation, or where an issuer's decision on a share offering may lead to a lack of an open market, an inadequate spread of investors, or may significantly and negatively affect the trading of shares in the secondary market, the overall coordinator should explain its concerns and advise the issuer against making a decision. The OC should also document any final decisions of the issuer which deviate materially from the advice or recommendations provided by the OC, including the OC's explanation to the issuer of any concerns associated with the decisions and the advice provided. In the case of a share offering, the OC should report to the SFC any issuer decisions that amount to material non-compliance with the exchange's requirements on placings. The proposed code will require an overall coordinator to advise and assist the issuer in developing an appropriate marketing and investor targeting strategy, which should take into account the issuer's objectives and preferences. The strategy may specify the types of investors targeted and the proportion of an offering to be allocated to each type of investor to establish the desired shareholder or investor base. For IPOs, the strategy should also include the types of investors who may be appropriate cornerstone investors and aim to achieve an open market and an adequate spread of investors and promote the orderly and fair trading of shares in the secondary market. An OC should also advise the issuer to adjust the strategy as appropriate in response to changing market conditions and sentiment. OCs should inform other syndicate CMIs of the marketing and investor targeting strategy, and syndicate CMIs would be required to inform CMIs they engage of the strategy so that they can serve as a basis for their selling activities. CMIs should not market to investor clients falling outside the strategy. On a share offering where the shares are only marketed to selected investor clients, CMIs should be satisfied that the shares are marketed to a sufficient number of investor clients to minimize the likelihood of an undue concentration of shareholdings. Investor clients who fall within the strategy, but to whom the CMI does not actively market, should have the opportunity to participate in an offering if they show interest. With respect to rebates and professional treatment, it's proposed that CMIs should not offer any rebates to their investor clients or pass on any rebates provided by the issuer. In addition, on IPOs, capital market intermediaries should not enable investor clients to pay less for their shares than the total consideration disclosed in the listing document, including the 1% brokerage fee. On debt offerings, capital market intermediaries should not enter into any arrangements which may result in investor clients paying different prices for the debt securities. A CMI will be required to disclose to the issuer, the overall coordinators, all of its targeted investors, and the non-syndicate CMIs it appoints, any rebates offered by the issuer to CMIs, and any preferential treatment of any CMIs or targeted investors. On a share offering, a CMI should make the disclosure upon becoming aware of any rebate or preferential treatment. On a debt offering, disclosure should be made no later than the dissemination of the deal, launch message to targeted investors. The proposed code will also impose an obligation on overall coordinators to disseminate the information they receive about rebates or preferential treatment to all syndicate capital market intermediaries for their onward disclosure to targeted investors and to non-syndicated CMIs they appoint. The OC will be required to advise IPO issuers against providing any arrangements which would allow investor clients to pay less than the total consideration disclosed in the listing documents. On debt offerings, the OC should advise issuers against providing any arrangements which would allow investor clients to pay different prices for the debt securities. The OC should also advise and guide the issuer in relation to the necessary disclosures. To ensure that investor clients fall within the categories identified by the marketing and investor targeting strategy, the proposed code will require CMIs to take reasonable steps to assess each investor's client profile, including their investment preferences and past investment history. This will be in addition to complying with the current KYC Know Your Client requirements under paragraph 5.1 of the SFC Code of Conduct. Under the proposed code, a CMI will be required to take reasonable steps to identify restricted investors. That's investors to whom the allocation of shares is either restricted or requires the prior consent of the exchange. Examples include connected clients and core connected persons. CMIs would have to inform the overall coordinator before placing an order on behalf of a restricted investor. The SFC further proposes that in order to facilitate the identification of restricted investors, OCs should provide more information to capital market intermediaries in respect of persons and entities related to the issuer. This will require overall coordinators to obtain a list of these people or entities from the issuer and provide this to all capital market intermediaries. An overall coordinator should also take reasonable steps to identify restricted investors so that they will only be allocated shares in accordance with the Hong Kong Exchange's requirements. In the case of debt offerings, the SFC proposes that a CMI should identify whether its investor clients may have any associations with the issuer, the CMI, or a company in the same group of companies as the CMI. The OC will also be expected to provide sufficient information to CMIs to enable them to identify these investors. The CMI should also inform the OC of these investors to enable the OC to assess whether any orders may negatively impact the price discovery process. The SFC considers CMIs to be responsible for ensuring that the price discovery process is credible and that the order book is transparent and incorporates only bona fide orders. An OC should ensure that the pricing and allocation recommendations made to the issuer fully take into account the principles and factors stipulated under the proposed code. The SFC has identified concerns regarding the use of X orders, where the identity of the investor is concealed. It therefore proposes to require the identities of all investors to be disclosed in the order book, except for orders placed on an omnibus basis. In the case of omnibus orders, the identity of the underlying investors will need to be provided to the overall coordinator and the issuer, but need not appear in the order book. Capital market intermediaries will also be required to take reasonable steps to ensure that all orders placed in the order book on behalf of their investor clients, the CMI itself and its group companies, represent bona fide demand. CMIs must not place knowingly inflated orders. CMIs should also make inquiries with their investor clients about orders which appear unusual and will be required to maintain adequate records of orders placed by its investor clients to substantiate that there are no fictitious or knowingly inflated orders placed in the order book. As to the OC's obligations, the OC will be required to ensure that the identities of all investor clients are disclosed in the order book, except for orders placed on an omnibus basis. If any orders appear to be unusual or irregular, the OC should make inquiries with the capital market intermediaries. The OC is required to consolidate the order book by taking reasonable steps to identify and eliminate duplicated orders, inconsistencies, and errors. It should also segregate and clearly identify in the order book any proprietary orders of CMIs and their group companies. The SFC noted observations by IOSCO that conflicts of interest between the issuer and the capital market intermediary or its investor clients can lead to under or overpricing. The SFC also highlighted concerns regarding the impact of conflicts of interest on the allocations of shares or debt securities. For example, cases of allocations being made to firms' most valued clients or to other parts of a firm's business. The SFC's thematic review further found that allocation recommendations were primarily based on the judgment of individual staff and their understanding of the issuer's objectives or preferences. CMI allocation policies, where these existed, generally gave insufficient guidance to staff, particularly on conflicts of interest. The SFC also found that documentation of allocation decisions and their rationale was generally insufficient to demonstrate compliance with an allocation policy and appropriate management of conflicts. To address these concerns, the SFC proposes that an OC should discuss with and advise the issuer on the final offer price, taking into account the results of book-building activities, the issuer's characteristics, and prevailing market conditions and sentiment. In the case of debt offerings, the OC should ensure that the orders placed by investors which have associations with the issuer, CMIs, and their group companies will not negatively impact the price discovery process. In line with the IOSCO recommendations, the SFC further proposes that an OC should develop and maintain an allocation policy, which sets out the criteria for making allocation recommendations to the issuer. The allocation policy will be required to take account of the issuer's objectives, preferences, or recommendations, prevailing market conditions and sentiment, and targeted investor type, characteristics and circumstances such as the client's financial profiles, investment experience, and objectives. It should also assess the spread of investors, such as the sizes and number of large holdings and the overall subscription rate for the offer. An overall coordinator should communicate the allocation policy to the issuer early to ensure that the issuer understands the factors determining allocation recommendations, and an overall coordinator's allocation recommendations should be made in line with the policy. In the case of an IPO, allocation recommendations should ensure that allocations to restricted investors comply with the Hong Kong Exchange's requirements and be made with a view to achieving an open market, an adequate spread of shareholders, and promoting the orderly and fair trading of shares in the secondary market. The OC should also document allocation recommendations provided to the issuer, including its rationale. Capital market intermediaries will also need to establish and implement an allocation policy to ensure a fair allocation of shares or debt securities to their investor clients, where they place an order on an omnibus basis and an OC gives them an overall allocation. The policy should set out, for example, the marketing and investor targeting strategy agreed with the issuer, investor clients' order sizes and circumstances, price limits for client orders, and minimal allocation amounts indicated by investor clients, and any applicable legal and regulatory requirements. CMIs should allocate shares or debt securities to investor clients in accordance with the allocation policy and document any reasons for material deviations from the allocation policy. When allocating shares or debt securities, a CMI is expected to assess whether the investor client has the ability to take up the allocation and whether the size of the order appears unusual. This also applies to an OC when making recommendations to the issuer regarding allocations of shares or debt securities to its own investor clients. The consultation paper expresses concerns relating to conflicts of interest, where CMIs or their group companies place proprietary orders in the order book. The concerns include that CMIs could take advantage of non-public information in the order book when placing proprietary orders to increase their chances of allocation, or on popular offerings may allocate more shares or debt securities to their proprietary orders than to their client orders. The proposed code will therefore require CMIs to establish and implement policies and procedures to identify, manage, and disclose actual and potential conflicts of interest with investor clients, which may arise when the CMI has a proprietary interest in an offering. A CMI will also be required to implement policies governing the process for generating its own proprietary orders and making allocations to those orders. The proposed code will also require CMIs to give priority to investor clients' orders over their own proprietary orders and those of their group companies. A CMI will also be required to be a price taker in relation to its proprietary orders and those of its group companies, and should ensure that these orders are based on market-driven demand and would not materially influence the pricing of the offering. Proprietary orders placed by a group company will exclude those placed on behalf of clients or funds and portfolios under its management, but will include orders placed on behalf of funds and portfolios in which the CMI or its group companies have a substantial interest. The overall coordinator and capital market intermediary should also segregate and clearly identify in the order book and book messages its own proprietary orders and those of its group companies, other CMIs and their group companies. The proposed code also says that on debt offerings, a CMI should take reasonable steps to disclose to the issuer why any risk management transactions it intends to carry out for itself, the issuer, or its investor clients would not affect the pricing of the new offering. The SFC proposes that the senior management of a CMI should review and approve certain types of orders and allocations, including proprietary orders of the CMI and its group companies. Orders from investor clients which appear unusual, for example, orders appearing to be related to the issuer, and allocations to restricted investors in the case of share offerings. According to reports by IOSCO, CMIs should provide a range of information to investors in share or debt offerings to set the parameters for price formation during the book building process. The SFC is therefore proposing that a CMI should disseminate material information relating to the offering to the OC, its investor clients, and the CMIs it appoints. CMIs should therefore provide information about restricted investors for a share offering. On a debt offering, CMIs should provide information about investor clients which have associations with the issuer, CMIs, and their group companies. CMIs will need to provide the information to the OC and non-syndicate CMIs appointed by them to enable them to properly discharge their duties. The proposed code will also require CMIs to disseminate the marketing and investor targeting strategy to non-syndicate CMIs to facilitate their marketing of the shares or debt securities to investor clients. CMIs should also provide book messages and other information related to the offering, such as information on rebates offered to CMIs, to the OC non-syndicate CMIs they appoint, and to their targeted investors. Overall coordinators and capital market intermediaries should also disseminate information in a timely manner and ensure that it's complete, accurate, and has a proper basis. The proposed code will also require a capital market intermediary to maintain books and records to evidence the work done throughout the transaction and demonstrate compliance with the legal and regulatory requirements and the CMI's internal policies and procedures. CMIs will be required to document key communications with the issuer, investors, and other CMIs and the basis of allocation decisions with justifications of any material deviations from the CMI's allocation policy. The record should also include an audit trail from the receipt of orders through to final order allocation. OCs will also be required to document all changes in the orders in the order book throughout the book building processes and all key discussions with and key advice or recommendations provided to the issuer. General Principle 3 of the SFC Code of Conduct requires an intermediary to have and effectively employ the resources and procedures which are needed for the proper performance of its business activities. The proposed code will set out specific requirements for CMIs. First, the proposed code contains requirements for Chinese walls for a CMI, which is a company or part of a group of companies that undertakes multiple activities in relation to an offering. For example, research report preparation, book building, placing, and sponsor work. These CMIs will be required to take adequate measures to prevent the flow of information which may be confidential or price sensitive amongst staff performing different activities and to prevent and manage any conflicts of interest which may arise. In particular, CMIs should maintain effective Chinese walls and wall crossing policies and procedures. The SFC is also proposing that when a CMI appoints a non-syndicate CMI, that's a sub-placing agent, it should exercise due skill, care, and diligence in selecting and appointing the non-syndicate CMI, which will require the CMI to take reasonable steps to ensure that the non-syndicate CMI is able to comply with the proposed code. This may require the CMI to review the non-syndicate CMI's marketing strategy and assess how it ensures that all investor clients which are targeted investors and have indicated an interest in the offering are allowed to participate in the offering. The CMI will also need to review the non-syndicate CMI's process for assessing whether investor clients are independent from or associated with the issuer and its procedures and controls to ascertain whether all orders are bona fide. The CMI would also be expected to review the non-syndicate CMI's allocation policy to ensure that it addresses the requirements under the proposed code and the procedures to ensure that allocation is made in compliance with that policy. The proposed code will also require CMIs to conduct independent surveillance and monitoring on a regular basis to detect irregularities, conflicts of interest, and leakage of price-sensitive or confidential information and any potential non-compliance with applicable legal and regulatory requirements or their own internal policies and procedures. Owing to concerns from a number of buy-side and sell-side participants regarding fluid syndicate membership and fee arrangements, the proposed code will require fee arrangements to be specified in the written agreements with capital markets intermediaries and overall coordinators, and overall coordinators will be required to advise issuers on the fee arrangements. The SFC does not, however, consider this sufficient to address what it considers to be a root cause of undesirable intermediary behaviour. The SFC considers that the determination of syndicate membership and fee arrangements at an early stage of the offering would allow overall coordinators and capital markets intermediaries to better focus their efforts and resources on providing advice to the issuer and conducting Hong Kong book building and placing activities in compliance with the proposed conduct requirements. It further expects that this would improve the transparency and credibility of the price discovery and allocation process. The SFC also notes that early agreement of fixed fees is consistent with international market practice, including in the US and UK. Under the proposed code, the fixed fees payable to the overall coordinator should be determined at the time of their appointment, and these should also cover the advisory services provided by an overall coordinator and proportions of shares or debt securities ordinarily expected to be sold by the overall coordinator. The issuer can subsequently appoint other syndicate capital market intermediaries and at the time of their appointment determine their fixed fees based on the volumes they are expected to sell. The SFC clarifies that issuers can still pay capital market intermediaries discretionary fees to incentivize sales outperformance. The SFC further says that it considers it appropriate for the ratios of fixed fees to discretionary fees and allocations of fixed fees to syndicate members to be agreed at an early stage. The SFC therefore proposes that each written agreement to be entered into by an overall coordinator or a capital market intermediary should specify the fee arrangements, including the allocation of fixed fees to the particular CMI as a percentage of the total fees to be paid to all syndicate CMIs and the fee payment schedule. The proposed code will also require an overall coordinator to advise and guide the issuer on fee-related matters and specifically on determining the ratio of fixed to discretionary fees to be paid to syndicate capital markets intermediaries and the basis of allocation of fixed fees to syndicate CMIs. Overall coordinators should also advise issuers on the basis of allocation of any discretionary fees to syndicate CMIs. In the case of a debt offering, this allocation should be determined no later than at the time of pricing. Overall coordinators will also be expected to advise issuers on the fee payment schedule. The SFC further proposes that certain information should be submitted to the SFC 4 clear business days before the listing committee hearing for an IPO. Information about the syndicate members, indicating their roles, the total fees to be paid to all syndicate capital markets intermediaries, the ratio between the fixed and discretionary portions of the fees to be paid to all syndicate capital markets intermediaries in percentage terms, and the allocation of the fixed portion of the fees paid by the issuer to each syndicate CMI participating in the offering. The SFC says that issuers may alter the fee allocations as an IPO timetable progresses. However, the SFC should be informed of any material changes once they are agreed between the issuer and the syndicate CMIs and of the reasons for the change. As regards discretionary fees, the SFC proposes that a confirmation should be provided to the SFC no later than listing that the issuer has determined allocations of any discretionary fees to each syndicate CMI, as well as the fee payment schedule. Total monetary benefits, including fixed and discretionary fees and any bonuses paid to each syndicate CMI by the issuer, should be provided to the SFC within 2 weeks after the first day of dealings. Additionally, the SFC noted that some market participants are in favour of issuers making public disclosure of the names of syndicate members and overall coordinator at an early stage. These participants also support public disclosure of all underwriting fees for IPO transactions, which are disclosed in the prospectus for the Hong Kong public offer tranche, but infrequently disclosed for the international placing tranche. Some market participants are in favour of public disclosure of the total monetary benefits, including fixed and discretionary fees and any bonuses paid to each syndicate capital market intermediary after the completion of the IPO. Turning now to the sponsor coupling proposal. This would require that on IPOs, at least one overall coordinator should also act as a sponsor, which is independent of the issuer, or be in the same group of companies as a sponsor, which is independent of the issuer. The SFC views there to be advantages when heads of syndicate also act as IPO sponsors, primarily due to the extensive knowledge sponsors gain about issuers during the due diligence process. However, the number of syndicate heads which did not act as sponsors increased in the first 9 months of 2020 compared with 2018. The SFC also points out to a misalignment between the fees paid to sponsors and sponsors' costs, which can be substantial, and potential liabilities. Sponsor fees are generally substantially lower than underwriting fees. In the 9 months ended the 30th of September 2020, the average sponsor fee was 6.3 million Hong Kong dollars, while the average underwriting fixed fee was 43.9 million Hong Kong dollars. According to the SFC, where the sponsor also acts as the head of syndicate, the total fees may properly compensate the sponsor for its sponsor work and potential liability as sponsor. Conversely, if sponsors are not appointed as head of syndicate, the SFC is concerned that they may compromise their due diligence work. It's worth noting here that this idea that the problem of artificially low sponsor fees and concerns about sponsors skimping on due diligence could possibly be solved by requiring sponsors to act as heads of syndicate is completely in contradiction, apparently, with the thinking behind the sponsor regime introduced in 2013 by the SFC. In the SFC's 2012 consultation paper on sponsor regulation, it was recognized that sponsor fees often did not reflect the amount of work required of sponsors. The solution then was for sponsor fees to properly reflect the amount of work required. The consultation conclusions back then said that sponsor fees should appropriately reflect the role and responsibilities to be discharged by a sponsor and should not be confused with other services, notably book building, pricing, and other similar functions governed by underwriting and related agreements. According to the consultation paper, the SFC's soft consultations found that market participants opposed proposals to require all overall coordinators to be sponsors based on concerns that it would limit the issuer's flexibility in appointing overall coordinators whose strengths are primarily in marketing rather than sponsor work. Similarly, the proposal could prejudice standalone boutique sponsor firms with no marketing capabilities. According to the consultation paper, 72% of IPO sponsors acted as syndicate members in 2020. The SFC's proposals could disadvantage these smaller boutique sponsors. While they're very often competent as sponsors, if they lack underwriting capabilities, they will be prevented from acting as overall coordinators. They could be appointed as co-sponsors, but this would require the issuer to double the sponsor fee payable. The SFC is proposing that a listing applicant should appoint at least one sponsor, which is independent of the listing applicant, who should also be appointed as an overall coordinator, or have a group company which is appointed as an overall coordinator for the IPO. This role is referred to as the sponsor overall coordinator. The test for sponsors' independence is set out in the listing rules. The sponsor OC will need to be appointed as overall coordinator and sponsor at the same time and at least 2 months before filing the listing application. The listing applicant can appoint other overall coordinators, which may or may not be sponsors of the IPO, no later than 2 weeks after the submission of the listing application. The SFC hopes that the proposals will ensure that at least one sponsor will be free of potential incentives to limit due diligence in order to secure an overall coordinator role, and that the sponsor overall coordinator will be in a position to give comprehensive advice to the listing applicant throughout the transaction. A further aim of the SFC is that buy-side participants will be able to look to the sponsor overall coordinator to provide well-informed and authoritative answers to their questions. The proposed code will require that before accepting an appointment by the issuer to act as an overall coordinator, an OC should either ensure that it or one of its group companies is also appointed as a sponsor, which is independent of the issuer client, and that both appointments are made at the same time, at least 2 months before the submission of the listing application to the exchange, or they should obtain a written confirmation from the issuer that at least one sponsor, which is independent of the issuer client or one of their group companies, has been appointed as an OC for that IPO. The OC's appointment should be made no later than 2 weeks after the submission of the listing application to the exchange. The SFC is also proposing to revise paragraph 17 to the Code of Conduct, which applies to sponsors. Before accepting an appointment by a listing applicant to act as a sponsor should either be independent of the listing applicant and ensure that it or one of its group companies is also appointed at the same time as an OC in connection with that listing application, or it should obtain written confirmation from the listing applicant that at least one sponsor which is independent of the listing applicant or one of the group companies of that sponsor has been appointed as an OC in connection with that listing application. The sponsor OC would also be expected to submit information on the syndicate membership, the total fees to be paid to all syndicate CMIs, and the allocation of fixed fees, as required under paragraphs 21.3 and 21.4 of the proposed code, within the prescribed timeframe. If more than one intermediary is appointed as a sponsor OC, they should arrange for one of them to provide this information to the SFC. However, each sponsor OC will be jointly and severally liable for ensuring that the information is accurate and complete and has been provided to the SFC within the stipulated timeframe. In terms of the impact of the proposed changes, there are different views depending on who you speak to. The issues that concern the bulge bracket banks who offer the full range of services from acting as IPO sponsor and underwriting are different to those concerning some of the boutique sponsor firms who don't have underwriting capability. The issues on mega hot issues, which are many times oversubscribed, are also very different to those on listing smaller companies, particularly on GEM. On the issue of the overall coordinator acting as the advisor to the issuer, some banks are concerned about liability. There was a case in the US, EBC 1 Inc. against Goldman Sachs, which held that the underwriter had a fiduciary duty in advising the issuer on its IPO. Following that case, US underwriting firms developed a practice of adding a clause to their underwriting agreements requiring issuers to acknowledge that they were not relying on the underwriters for financial advice. The concern for US banks then is that in their capacity as underwriters and global coordinators rather than as sponsors, the SFC will require them to act as advisors to the issuer and take on liability which they would normally seek to exclude. On the sponsor coupling proposal, a key issue is that this seems to be at odds with the aim of the 2013 sponsor regime. The SFC's focus then was on ensuring sponsor independence, which was thought necessary to ensure the objectivity of the sponsor's due diligence. The SFC's original proposal was that there should be only one IPO sponsor, which would have to be independent of the issuer, or if there were multiple sponsors, that they should all be independent. Ultimately, the SFC agreed that only one sponsor needed to be independent. There are a couple of potential issues with the sponsor coupling proposal. The first is the potential conflict of interest between the overall coordinator as the lead underwriter and the issuer. As the consultation paper notes, the IOSCO report on conflicts of interest in the equity capital markets highlighted the risk of an IPO underpricing due to the inherent conflict between the interests of the underwriters and the issuer. While it's in the issuer's interest for the share price to be as high as possible, it may be in the underwriter's interest to underprice the offering to increase the chances that all the shares are subscribed by investors and minimize the prospect that they will have to purchase the unsubscribed shares. Given that inherent conflict, there's an argument against the overall coordinator advising the issuer on price. Underpricing of IPOs is not, however, addressed in the consultation paper, which notes the SFC's concern that competitive pressures between brokers, as in the SFC's words, tip the scales in favor of issuers. In addition, sponsor coupling could be particularly problematic on deals where there's only one sponsor or only one independent sponsor. If an OC decides it no longer wants to underwrite an IPO, there's currently no problem. The issuer can appoint a replacement OC if they can find one, with no consequences for the listing timetable. However, if an OC, which is either the sole or the only independent sponsor, is in place, a new listing application would need to be submitted because of the listing rules requirement that sponsors are appointed at least 2 months before the submission of the listing application. This could cause a substantial delay in the listing and additional costs, and could effectively allow an overall coordinator, which is the sole or sole independent sponsor to use this as negotiating power with the issuer when it comes to agreeing the pricing. In not addressing this inherent conflict between the overall coordinator and the issuer, there are concerns that the sponsor coupling proposals risk exacerbating the position in entrenching the conflict where the overall coordinator is the sole or sole independent sponsor. Some have suggested that IPO issuers should instead be advised separately by an independent financial advisor on matters such as pricing and allocation. This would enable issuers to receive impartial advice and put them in a proper position to agree the pricing and the conduct of the distribution of the shares. The sponsor coupling proposal will also disadvantage boutique sponsor firms which don't have underwriting capabilities. In theory, these firms could be appointed as joint sponsors. In practice, as I mentioned, issuers may be unwilling to pay more than one set of sponsor fees. The sponsor coupling proposal would therefore effectively preclude these boutique sponsor firms from acting as IPO sponsors. The SFC sees the sponsor coupling proposal as a means to address its concern that sponsors may compromise their due diligence inquiries to win the profitable role of syndicate head, for which they generally face fierce competition from non-sponsors. Part of the answer to that concern could be to ensure that sponsors are properly compensated for their work and potential liability as sponsors. Although the SFC commented in its 2012 consultation conclusions on the sponsor regime that sponsorship fees should reflect the sponsor's role and responsibilities, no provision to that effect was in fact included in the Code of Conduct. The concern regarding sponsors potentially skimping on their due diligence could perhaps be addressed by making it a requirement that sponsor fees properly reflect the work and potential liability of the sponsor under paragraph 17 of the Code of Conduct. The SFC also has ample means at its disposal for dealing with sponsors which conduct inadequate due diligence, and there are many examples of the SFC bringing disciplinary proceedings against sponsors on this basis. On the issue of early appointment of overall coordinators and early fixing of fees, there are different views depending on the type of deal we're talking about and who you talk to. For the bulge bracket banks working on large IPOs, they're keen to have everything locked down as early as possible. They, and also some on the buy side, are in favour of knowing who the overall coordinators are and what their fees will be as early as possible. They see it as unfair that a bank can join the syndicate late and take a share of the fees because it's bringing, for example, a large cornerstone investor without putting in the work to understand the issuer and its business. By setting the syndicate's fixed fees early, the SFC is seeking to prevent what it describes as brokers swarming the order book at the last minute and bringing in large price-insensitive orders. For the banks working on smaller deals, particularly GEM IPOs, they envisage problems with the proposal that information about syndicate membership and fees for the deal will have to be given 4 clear business days before the listing committee hearing date. On smaller deals, underwriters are often unwilling to commit until there's some certainty that listing approval has been obtained and the deal will go ahead. There's also the problem that notice of listing committee hearings is often only given on Mondays for a Thursday hearing, which leaves very little time to conduct pre-marketing and get the syndicate in place. So there are a number of different issues which are difficult to deal with through a single set of requirements which apply across the board. And clearly, the position in relation to very large IPOs is very different from small to medium-sized IPOs. So that brings me to the conclusion of the formal part of this presentation. So thank you again for joining me today. I hope you all have a really great weekend.